immediate scene of a robbery. You are the trier of fact. The state proved beyond a reasonable doubt that a lane away, 3.5 miles away, is the immediate scene of a robbery. I would submit to you that it is not. As to if it's not premeditated murder, we haven't proved. It's not felony murder, we haven't proved. What is it? Another instruction I want to address briefly, the instruction on justifiable use of deadly force. I'm not arguing that. Under the law, any evidence comes before you, possible self-defense. That's the instruction. Yeah. This is not. There's evidence in the record, in the tape. Brandon Bradley be hurt. You going to shoot me? Why are you going to shoot me for nothing? You're going to shoot me for nothing? And while that indicates a fear of the dead, it's by the instruction, and you'll see it. It's not reasonable self-defense. So we're not arguing it, and you don't need to consider it. There's been a great deal of argument over intoxication by these folks with Brandon Bradley were impaired, wasted on drugs. And of course they were. We know it from the testimony of motel witnesses. Mr. Jordan looked like he wasn't even there. His eyes wasn't even there. From Vanessa McInerney looked high to me. We know from Andrea Kirchner, we've been drugging pretty much continuously for 2.5 weeks. Doing Xanax, weed, ecstasy, pretty much whatever we get our hands on. We know from their acts, it's on its face. During checkout at a motel, 10:30, 11 o'clock in the morning, furniture being moved downstairs, not under cover of darkness, not in the middle of the night, but in broad daylight. Everything. Sheets, comfort, nightstand. It, photos. Everybody needs a towel rack. And we all need a plastic cover to an air conditioning unit. State during their opening, the evidence would indicate that they were taking the air conditioner. And as it turned out, the evidence from the people, no, they just took the cover. And got the photos, you got your own common sense. Can you imagine those two getting an air conditioning unit or TV set down those stairs? And wouldn't it have been done under cover of darkness in the middle of the night? Andrea Kirchner, she didn't come across like a idiot on the witness stand. So what else would her action? Drug induced. We know from the bullets that shot into the door. We know that he was intoxicated, falling in the chairs during a statement, as well as from the 7 hours before when he couldn't be woken up and was falling from a chair during that time frame as well. And we know from the video of the actual event, when he leaves that motel, it's a straight shot. I would submit, and people can be wasted and make their way straight, at least for a while. Now, on video, first minute or so of the video is a driving pattern, and Mr. Bradley overshoots the first curve and appears to be headed straight. That goes into the other lane, and then the lane away turns and very nearly has a head-on with an oncoming vehicle and overshoots the intersection, does a U-turn. Instead of turning directly down the lane away, goes over into the egress lane from a lane away, loops back around, and then crashes in and knocks over a trash can. Maybe he's just a crappy driver. We know Andrea's testimony and the video from his statements. Why are you going to shoot me? Why are you going to shoot me? And those statements, you hear at least twice on the tape. And once at 11 on the clock on the video, you need to see 11, 10, 58, and 11, 11, 04. You need to, I found, you can't hear it real loud, but I found that earbuds or earphones are the best way to hear that. Now, if there's a question as to their intoxication or their impaired, if there's any question about that, why don't we know? Sheriff's Department didn't ask for blood. They didn't get a search warrant for blood. They didn't do it 10 hours later. They didn't do it 20 hours later. They didn't do it at all. They did everything they could to avoid talk about drugs, finding drugs in Mr. Bradley's system. The reason we did that is they didn't want you to have that evidence. The reason they didn't want you to have that evidence, I would say, is they wanted vengeance so much more because Barbara killed one of their own.
Rebuttal argument on behalf of the state.
Judge, please the court, counsel, ladies and gentlemen of the jury. We're almost there. The portion of the closing argument that I'm going to be giving is known as the rebuttal portion. As the name implies, I'm supposed to be addressing those points raised by the defense in their closing argument. I believe Mr. Brown did an excellent job of covering the basics and the facts and applying the facts to the various elements of the charges that the state has brought. And I'm not going to try to cover what he has already done. I would like to respond to some of what it was that Mr. Lanning brought up. Now, Mr. Lanning says that you can't rely on what the evidence in this case is because apparently the law enforcement folks, the state attorney's office, and the witnesses all have some ulterior motive to apparently put evidence before you that is not true, that somehow Mr. Bradley didn't do this. On the other hand, Mr. Lanning also says this is not a whodunit. He's essentially conceding to you that Mr. Bradley is in fact the one who shot Deputy Hill and killed him. He is saying that it's not a self-defense case. You don't need to worry about that. That's not a reasonable defense. We're not even going to argue that. So what is the real issue that Mr. Lanning is talking about in this case? Last night when I sat and I thought about what I might be covering in the rebuttal argument, I do what I normally do for this portion of the trial, and I try to narrow down what are the issues in this case. What really is the issue that we're all here on? Normally in my cases, it's, okay, you got the wrong guy. Yeah, the drugs were in my pocket, but I didn't know they were there. I mean, there is a real legitimate issue for a jury to resolve. There are different sides. One party takes one position, the other party takes the other. They all argue what the evidence shows, and you all have to make a factual decision as to what, in fact, the facts were. In this case, I don't see any issues. As Mr. Brown covered with you in his closing arguments, that the facts are overwhelming. Even without the defendant's statement, the facts are overwhelming. The facts fit the elements for first-degree murder. The facts fit the elements for robbery. The facts fit the elements for fleeing and eluding with the lights and sirens and the reckless driving. The facts fit resisting an officer with violence. What have we really heard during the course of this trial? The state has called witness after witness to testify for you in person from the witness stand about what they saw, what they heard, what they did, and how each of those witnesses testified showed you what it was that Brandon Bradley did over the course of a 1-year period, which led to the shooting death by him of Deputy Barbara Pill on the morning of March 6th of 2012. When there was cross-examination of those witnesses, in the cross-examination, it was primarily as to either the witness's criminal history, the witness's use of drugs himself or herself, or the defendant's use of drugs with the witness. That's what all of the testimony in this case has been about so far in the area of cross-examination. And primarily in the defense case in chief, that's all it was. 2 doctors who testified about the defendant's drug use and its effect on him. I submit to you, that is not an issue. That is not an issue in this case at this time, because this is the guilt portion of the trial. In the guilt portion of the trial, the judge is going to instruct her. You guys will get the same instructions that we got copies of. She's going to instruct you that voluntary intoxication resulting from the use of a controlled substance is not a defense to a crime. Evidence of a defendant's voluntary intoxication may not be taken into consideration to show that he lacked the specific intent to commit any crime. Yet Mr. Lanning is arguing to you, well, he's not exactly saying you have to take all of that drug use and brain damage and all of the other concerns that they say Mr. Bradley has and consider it, but you're supposed to be making the determination about whether there was actually premeditation in this case, whether there was an opportunity to reflect before Mr. Bradley did what he did. And he wants you to consider the defendant's voluntary intoxication. He wants you to consider the expert's testimony about how they believe he was under the influence such that he couldn't waive his Miranda rights on the issue of premeditation. And the judge says, you can't do that. The law says you can't do that. The judge is going to tell you that evidence of any abnormal mental condition is not a defense to any crime. Brain damage, any of the other stuff that you've heard about. Evidence of a defendant's abnormal mental condition may not be taken into consideration to show that he lacked the specific intent to commit any crime. Such evidence is to be considered by you only for the purpose of determining whether the defendant's interview was knowingly, voluntarily, and freely made. That's it. That's the only thing that type of evidence can be used for. Yet Mr. Lanning says, regarding voluntary intoxication not being a defense, this was a drug-fueled crime. So what? It is a crime, it was a murder, and his intoxication, whatever level it may have been, is not a defense. He says Mr. Dieguez can't be believed. He's got felony convictions. He says he would never forget the phone call. He says that's not believable. But what is it about Mr. Dieguez that actually hits home? I mean, aside from the fact that his testimony does coordinate, it does not dovetail because they don't say exactly the same thing, but it matches in essence with what Ms. Kirchner says was occurring in that vehicle while she was in it. And he testifies about it. As Mr. Brown told you, the chirps, the 2 little chirps of the siren going off to pull the vehicle over, clearly heard in Deputy Pill's video. How would he have known that if he wasn't listening? How would he have known about the conversation between Ms. Kirchner and a male, which he identified as Mr. Bradley's voice? How would he have known about that conversation unless he heard it? And Mr. Lanning has the gall to suggest to you, well, that maybe the state went and talked, or maybe Ms. Kirchner went and talked to Mr. Dieguez in that 5-week period. Or maybe Ms. Kirchner's lawyer went and talked to Mr. Dieguez in that 5-week period before the detectives found him and spoke to him. So maybe they asked him to testify to that. Folks, if someone had approached Dieguez and told him what to say, number one, they'd have done a better job of it in getting the stories to match. I mean, what Mr. Dieguez says does not exactly match what Ms. Kirchner says. This is not a rehearsed story that they're telling. And number two, why in the world would Mr. Dieguez sit back and wait for the cops to track him down? He didn't approach law enforcement with this story. He didn't go running to them and say, hey, listen, I can build up some points with Miss Kirchner, who I'd like to date someday. Even though she only dates the black guys, maybe I got a chance if I do something good for her. So I'm going to go to the cops, and I'm going to tell them some really good things that are going to be really helpful in her case. So she'll really be happy. And yet 5 weeks go by, he never approaches the cops. They have to track him down when they find the phone record that shows an open line, and his phone is at the other end of it. And what happens when they go to talk to him? He's in the hospital. He's apparently so drugged out of it, he does not even remember meeting with the officers, does not remember what he told them, doesn't remember anything about it, but we know what he told the officers. And what did he tell the officers? The exact same thing that he told you and that he told them in his deposition about what happened in that conversation. The one thing he has been absolutely consistent about from the day he was approached by the agents in April of 2012 is that what he heard was Miss Kirchner arguing with the guy in the car. And what was being said was, she's got my tag, she saw my face, I gotta kill that bitch, I am not going back to prison. Is that believable? I submit to you that is absolutely believable. We had to hunt that witness down. And think about the circumstances of hunting that witness down. This is now 5 weeks after the shooting. Miss Kirchner has already been arrested and charged with murder. They are looking to put her in the electric chair. Drugs, whatever the state is using nowadays. They are looking, as Mr. Lanning says, for vengeance, no question about it. A deputy, a member of our family has been killed, and yes, they want vengeance. But do they go there to look for someone giving evidence helpful to the person that they have charged? Absolutely not. They went there expecting to gather additional evidence to show that Miss Kirchner and Mr. Bradley acted together in killing Deputy Pill. And what did they find out? Something they really didn't want to hear. And Mr. Lanning says, well, the state jumped in right away and cut a deal with Miss Kirchner, cut a deal from the beginning. You all heard the testimony. She was arrested on March 6th of 2012. She pled in January of 2014, the same day the defense deposed her. 2 years. 2 years after she was charged, it took for us to be convinced that her participation in this case was as an accessory after the fact. Based on what Mr. Dieguez said, the other investigation that we did, and the records, it is clear that Ms. Kirchner attempted to talk that man out of killing Deputy Pill. And why did she do that? It's not because she loves cops. Mr. Lanning's absolutely correct. If you were able to hear or see the tapes of Ms. Kirchner that day, you would hear her say those things. I hate cops. I'd shoot the three of you. She could give a rat's ass about the cops. She was trying to save her own rear end. She didn't want Deputy Pill shot because, as she told you from the stand, you don't come back from that. I'm in a car with a crazy guy who's going to shoot a cop, and that's going to put me in jail. I don't want that. You bet she tried to talk him out of it, and I bet that conversation took a long time. And I'll submit to you that the way that conversation happened, because you only see on the in-car video the portion where Deputy Pill has actually caught up to Mr. Bradley's vehicle and turns on the lights and pulls it over as they pull into a lane away. That's all captured on the in-car video. But you got to remember the testimony was that Deputy Pill was going north or southbound on John Rhodes and passed the SUV as it was going northbound on John Rhodes. And the Kirchner and Bradley vehicle saw Deputy Pill's vehicle turn around and start to chase him. I submit to you what the evidence would show is that that's when that conversation started. That's when Mr. Bradley realized she saw my face because she's not going to see his face from behind. She could only see his face in that car as she was going toward it. Mr. Bradley knew from the moment that that police car started turning around after she saw his face behind the wheel of the car that they had the tag number. He knew they had the tag number at the hotel. That the hotel employees were telling him, "We got your tag number. We're going to call the police. Just give us the property back." But no, he couldn't do that. He had to listen to Miss Kirchner saying, "Go, go," and he helped her leave the hotel with the property, participating in the robbery. I don't care whether he personally carried anything down to the car. He says he knew that the property was stolen. Two witnesses say he actually did help carry it down, both Miss Kirchner and Mr. Montesano. But even if he didn't carry it down, even if he just realized it was stolen property when he got there, he nonetheless assisted Miss Kirchner from that point in escaping with the stolen property by getting behind the wheel of the car and driving away, threatening Mr. Jordan in the process. If he doesn't run away, if he doesn't jump out of the way, if he doesn't move, I'm just going to run you over because I am leaving. That, my friends, is robbery. That is him participating in it, whether he carried the property or not. Mr. Lanning says it's not felony murder. Two reasons. One, there was no robbery. This is clearly overcharged. This is a theft by Ms. Kirchner that Mr. Bradley didn't even have any participation in. As I just told you, that's just not accurate. If you believe the two witnesses that Mr. Bradley carried the property, he was actively involved in the taking the property out of the room. Even if you don't believe them, by the other testimony, he assisted in being the classic wheelman, if nothing else. You hear about bank robbery people. The guy never goes into the bank. All he does is drive the car to or from or whichever, and that's participating in the bank robbery even though you're not in the bank. Same with Mr. Bradley in this case. Even under Mr. Lanning's theory of Ms. Kirchner doing it all and taking it all, which doesn't make much sense, and you have to disbelieve the witnesses, then still getting behind the wheel of the vehicle and doing what he did after that point constitutes the robbery. He then argues that, well, it's not leaving the immediate scene. He's not fleeing from the immediate scene. He focuses on immediate scene of a robbery. That is element 2 in the felony murder instruction. You all have a package of these. You can look at them yourself. The entire sentence reads, "The death occurred as a consequence of and while Brandon Lee Bradley was escaping from the immediate scene of a robbery." No question he was escaping from the immediate scene of a robbery, which is, the immediate scene is the hotel, but he was in the process of escaping from that location, and he only made it 3.5 miles. And it was a continuous thing. As Mr. Brown said, he didn't stop any place. He had never reached a safe haven. He went basically, essentially, straight from the hotel down John Rhodes, where he was picked up by Deputy Pill. The stop ultimately occurred, and they went to Elena Way. So I submit to you that, and if you read that, you have to read that instruction in conjunction with the robbery instruction, because the robbery instruction is going to tell you that the taking can be done in a number of different ways, but as long as it can be a continuous series of acts, as long as this action is a continuing thing, if the taking of the property and the use of the force is a continuous thing until the apprehension, that is still in the course of the robbery. So reading those two instructions together, you will see that stopping the vehicle 3.5 miles away from the hotel 10 or 15 minutes after the robbery occurred is clearly in the continuous action of the robbery. They're still in the process of fleeing during the robbery. They have not stopped any place, haven't done anything else. That is all part of the evidence and establishes element number 2 on the felony murder. Then he argues that there's no premeditation here. This is all just a drug-fueled crime. Number 1, drug-fueled, forget about it. You don't need to consider it. Is there premeditation here? Mr. Brown went through the long series of events with each witness. I'm not going to go over it again, but let's just think about this for a second. It started over a year before the shooting of Deputy Pill. I told you in my opening statement. February of 2011, 3 warrants for violation of probation are issued for the arrest of Mr. Bradley. He knew about it. The probation officer told you he knew about it because he wasn't reporting in the way he's supposed to be. Amanda Osborne told you when we called her as a witness, yes, the defendant absolutely was aware of the outstanding arrest warrants. He got nervous every time he saw the cops, said he would run, got really nervous around police, did not want to go back to prison. Mr. Bradley has been thinking about what's going to happen to him and what he is going to do if he's pulled over by the police since February of 2011. He knows in November of 2011 that he's got a gun. He buys it. Buys it from Mr. Marks, the fellow who's currently in prison for stealing it from his brother-in-law and selling it to the defendant. He's got ammo for the gun. He's carrying it with him. Amanda Osborne says he carried it. Andrew Kirchner says he carried it. And why is he carrying it? In his statement, he says, well, because I live in the hood, and it's a rough neighborhood, and everybody carries a gun for protection, and I had a beef with some guy, and I'm carrying it for him. That may well be true. Those may be reasons also why he's carrying a gun. But do not believe for a second that he's not carrying that gun in case he gets pulled over. Because he knows if he gets pulled over, he's got to do something or he's going back to jail. And there's one thing that Mr. Bradley knows beyond all others. He is not going back to jail. What happens now on the morning of March 6, 2012 that really puts it all into focus for premeditation? He's at the hotel. They're getting ready to leave. Whether he participates in the initial taking of the property or not, he knows that there is stolen property in his car. He knows he's got outstanding warrants. He knows that they have been caught with the stolen property in his car and that the hotel folks are calling the police. This is now, what, 20 minutes, 15, 20 minutes before the actual shooting. He knows the cops are coming. He knows he's got the warrants. He knows he's got stolen property in his car. He knows if the cops come and stop him, he's going to jail. That's why he almost runs over Mr. Jordan. I don't think it was because he was that concerned about the property. If it's only property, he could have taken it out and given it back to him. As Mr. Jordan said, they initially told him, just give us our property, you can leave. We won't even call the cops. But he didn't do that. He's more worried about the cops coming than anything. So he takes off, almost running over Mr. Jordan. And you've got to believe when he leaves that hotel, knowing that they've got his tag, knowing that they're on the line with 911, he knows they're going to be looking for him. So he is thinking now, what am I going to do? Then he's driving down John Rhodes. I mean, it's only 3 miles away, 3.5 miles away. Less than that, actually, because where he was first spotted was up the road. And he sees a police car coming at him. And he sees the police officer looking at him. She saw my face. Now she saw my face. She's got my tag. And oh crap, she's turning around. Now she's coming after me. What am I going to do? What am I going to do to keep me from going back to jail? And what does he say? What does Ms. Kirchner say he says? And what does Mr. Diegas, Ms. Kirchner, but what does Mr. Diegas say here? Give me the gun. Give me the gun. I got to kill this bitch. He's saying that as he's driving down the road. Mr. Landing is talking about how he's driving erratically when the video first comes on. He says it's because he's impaired. How do you know it's not because he's trying to get the gun out of his vest or his pants or in the car, out of the console, wherever it was he got it from? He's getting the gun out because he's preparing to kill the person who's about to put him back in prison. But now Deputy Pill is right behind him. Now she's got her siren, the little chirps of the siren, and her lights are on and the video has started. What is he thinking now? And how long does he have to think about it? The in-car video from Deputy Pill is in evidence. If you look at it, the first frame starts at 11:07 and 18 seconds. That's the first frame you see on her in-car video. Maybe 17 seconds if your eyes are faster than mine are, but that's the first one I saw. If you continue to watch it, you will see that the shots are fired at 11 minutes, 11 o'clock, 11:10 is what it shows on the video. 11:11 in the morning and 10 seconds. That is 3 minutes and 52 seconds from the time that the video comes on until the shots are fired and Deputy Pill is killed. 3 minutes and 52 seconds for this defendant to reflect on what it is he's going to do, how he's going to do it, and to make a decision about whether he's going to kill her or not, as Ms. Kirchner has begged him not to. 3 minutes and 52 seconds. Starting now. Deputy Bill just died.
Ladies and gentlemen of the jury, would be appropriate now for us to break for lunch. I want to give you a heads up with regard to the schedule. When we come back, I will read to you the final instructions. You will have a copy in writing for your review. You can write on those if you wish to. It will take approximately an hour for me to read those. You can follow along while I read those with your copy. And then after I read the final instructions, we will go into deliberations. It will be, you will not be sequestered, and it will be up to you how long you wish to deliberate. We have no preference. We are totally here at your disposal. If you wish to go past dinner time, that's appropriate as well. We will provide some food for you if you do that. If you wish to recess and come back the next day, you'll just have to let us know what is your preference with regard to deliberation. And so that's why I tell you this now, so if you need to make some phone calls, I don't know what your collective preference will be, but we are at your disposal, whatever you decide to do. Now, we're going to break until 1:30. During this, but I'm going to give you a little extra time just in case you need to do something to prepare or what you need to do. During this recess, you must continue to abide by your rules governing your service as a juror. Do not discuss this case among yourselves. Do not discuss this case with anyone else or allow anyone to discuss it in your presence. Don't speak to the lawyers, the parties, or the witnesses about anything. You must avoid reading newspaper headlines and/or articles relating to this trial or its participants. Avoid seeing or hearing television, radio, or internet comments about this trial should there be any. And do not conduct any research yourself regarding any matters concerning this case. Okay, we will be in recess until 1:30. Report to the jury assembly room at that time.
All rise.
Okay, please be seated. Any matters that we need to address before we recess on behalf of the state?
Yes, Your Honor. During the defense closing argument, they essentially conceded that Mr. Bradley is guilty of the lesser charge of the murder, and have told the jury that they're not arguing self-defense because it's not a reasonable position. The state would like the court to inquire of the defendant as to whether he's willing to discipline his strategy.
And I can represent that I discussed this well in advance, and I explained everything to Bradley. He's in agreement.
Okay, Mr. Bradley, do you consent to the way that your attorneys have handled your case at this time? Okay, do you understand that they are not arguing self-defense at this time, and you agree with that strategy?
Yes, ma'am.
And do you understand that in their closing argument, they have conceded a lesser offense with regard to the first-degree murder charge? Do you understand that?
Yes, ma'am.
Okay, and you agree with that strategy?
Yes, ma'am.
Okay.
Judge, I believe the defense table mic is off. I just want the record to reflect that he answered yes to each of the court's inquiries.
Actually, they turned his mic on for that purpose. His mic was on.
Thank you, Judge.
Okay. Anything else we need to address on behalf of the state? Anything else on behalf of the defense?
No.
Do we want to change the jury instructions take out the self-defense, or do we leave that in?
I think it ought to be left in. It was in the packet, and not to say if there's any shred of evidence to support it. It ought to be in there. We discussed it with the jury, so I agree.
Okay, I just wanted to make sure. One less page, but hey, I'll be happy to read it. Okay, anything else on behalf of either party? No. Okay, we'll be back here at 1:30. Be back here at 1:30. Court's in recess until 1:30.